Our fourth panel today is in many respects both creative as well as cumulative of topics that have been touched upon today. And it provides this distinguished panel with an opportunity to explore some themes and ideas kind of outside the more narrow context of some of the panel subject areas. The panel topic is new issues in technology landscapes concerning privacy. And it asks us to think about questions such as, what is the role of government in dealing with privacy-threatening technologies? What are the important issues facing privacy law and protectors of privacy in America, in government, NGOs, academic settings, and private industry? It also asks us to think about what is government, including political institutions, doing to protect privacy while at the same time balancing other paramount governmental roles and responsibilities. And is that enough, what is being done? We have an array of experts to speak to you on these topics this afternoon. Their lengthy, thoughtful resumes have been provided for you, so I will briefly describe their backgrounds to help set up their presentations. Next to me is Robert Atkinson, the Vice President for the Progressive Party Institute and Director of its Technology and New Economy Project. Rob is a PhD in City and Regional Planning from University of North Carolina, an author and scholar on a number of publications concerning economic and technology issues. And as his resume shows, he has an extensive background in public policy issues concerning or facing federal and state governmental entities as well as non-governmental organizations. He has been recognized in many ways for his work in several areas of government policy, economic development, and technology. Peter Sand will also speak to us today. Peter is the Director of Privacy Technology. Maybe I'll put these individuals in order here, and so that you will know who they are as I introduce them. Next to Rob is Jim Harper. Jim is the Director of Information Policy Studies at the Cato Institute. He is a graduate of the UC Hastings School of Law. And in his capacity at the Cato Institute, he serves as an advisor to the Department of Homeland Security's Data Privacy and Integrity Advisory Committee. He has published scholarly pieces in several legal journals, and he also serves as an editor of an online think tank devoted exclusively to privacy issues, privacilla.org. Next to Jim is another Jim Dempsey, who is currently serving as Policy Director of the Center for Democracy and Technology. He formerly served as that entity's Executive Director. Jim Dempsey is a graduate of Yale College and the Harvard Law School, practiced law in Washington, D.C. at Arnold and Porter. And as his resume demonstrates, he's served in several capacities, including appointments to government, for example, the House Judiciary Subcommittee on Civil and Constitutional Rights, non-governmental entities such as the Center for National Security Studies and National Security Archives, and other groups and organizations. Jim Dempsey is the author of several books on issues concerning privacy, constitutional law and policy, and terrorism. Next to Jim is Joan McNabb, the Chief Privacy Officer for the state of California. Her office provides a resource, or serves as a resource and an advocate on identity theft and related questions, and provides privacy practice recommendations. She too serves as an advisor to the Department of Homeland Security. She's a graduate of Occidental College and thereafter earned a master's degree in medieval literature from the University of California, Davis. In the Q&A session, you can ask Joan whether her background in medieval literature is helpful to her in understanding state government policies and practices in technology and privacy. I believe next to her is Peter Sand. Peter serves as the Director of Privacy Technology at the Department of Homeland Security for the past year. In this capacity, he's responsible for coordinating the integration of privacy awareness and protections within the department's vast areas of responsibilities. Many of these responsibilities were generated by the E-Government Act of 2002 and, of course, the Homeland Security Act. Prior to that, Pete served as the Chief Privacy Officer and CIO for the Pennsylvania Attorney General's Office. Finally, on my far left, you have met earlier today Mr. William Fenwick, founding partner of Fenwick & West. Mr. Fenwick, I think, was introduced to you earlier. His resume demonstrates his many personal and professional activities, appointments, and engagements in the area of privacy law and the contemporary application and use of technology in complex corporate settings. He is a graduate of Southern Illinois University and the Vanderbilt University School of Law, a distinguished panel. Let me tell you what we're going to do here. Rob Atkinson is going to deliver the central theme and content of a paper he has prepared for the conference. When he's done, each of our panelists is going to be given a couple of minutes to offer some comments, reactions, shots, whatever, in response to Rob's presentation. And then I'll ask our group here if they would have some questions of Rob. Thereafter, each of our remaining panelists will be provided a 5-6 minute time period to give a presentation on an interesting development, public policy issue, statutory scheme, or other topic of current or forward-looking, future-looking importance. We have considerable expertise, some interesting topics to talk about, so let me start off by asking Rob Atkinson to tell you about what he's been researching.
All right, well, thank you. It's a pleasure to be here. I'm reminded of the guy on the TV commercials you've all seen. He says, I'm not a lawyer, but I'm a doctor, but I play one on TV. I feel like I'm not a lawyer, but I'm going to pretend to be one today. I actually am not a lawyer, and most of what I've been doing in this area has been coming at this issue of the relationship between, in most cases, the information technology revolution and public policy. And in particular, in the last few years, we've been looking at the nexus of those issues with regard to how government uses information technology and what kinds of things that the government ought to be doing, both in terms of adopting technology and also putting in place rules. So we've done a lot of work, which is all on our website, ppionline.org, on a paper on RFID, on internet privacy. We were big proponents of driver's license modernization, and we're behind the Moran-Davis bill to essentially put a chip on everybody's driver's license. So just know right off the bat where I'm coming from on this. And what I want to talk today about is sort of this, I think, sort of how we need to be thinking about the relationship between technology and government and privacy. And let me start by a case that I was just reading about last week that is sort of a live case in Britain. It's the automatic number plate recognition system. And what the Brits have put in place, or in the midst of putting in place, is a system that essentially says it will be impossible or virtually impossible to drive in England or in Great Britain and not have your driver's license be photographed by a camera that will have optical character recognition capabilities, identify your plate, link it to a database in real time to see if you're related to any of the plates that law enforcement is looking for. And this system has provided and could provide a vast array of benefits. One of the benefits was a child was abducted, put in the trunk of a car. Witnesses saw the car and knew the license plate, and shortly thereafter the cameras identified the car driving a certain number of kilometers away, and the police were able to stop the car and save the child. As you can imagine, though, privacy groups in the UK are up in arms. They're claiming that this technology is basically, half a step towards from this Orwellian nightmare, which Orwell was a Brit after all. But this is not just a debate about this camera system for driver's license. We see this debate here in the U.S. on an ongoing basis, and it's about data mining systems like the Matrix program that was being funded, ARPA's Total Information Awareness, CAPS-2, Secure Flight, a whole set of issues around remote surveillance, Easy Pass, or I don't know what you call them out here, the road transponders for toll roads, red light cameras, and certainly a whole set of issues around chip technology on identification documents. Proponents of these systems, and I'd put myself in that camp, would argue that these technologies will provide vast amounts of benefits, both in a direct sense to improving government missions and in indirect senses. For example, if we had chips on driver's licenses, those could be used for a whole wide array of e-commerce applications and would significantly boost economic productivity. Obviously, many in the privacy community, not all, but many people would oppose these technologies and would argue essentially that the answer is to ban the technologies, or to put in place rules and regulations that are so strict that they essentially strangle the technology, so they, for all intents and purposes, won't be used. And I won't go into a lot of the cases, but by and large, I'd say that side is winning. CAPS-2 was DHS decided they wouldn't deploy CAPS-2. Now they're sort of in the midst of Secure Flight. Who knows what's going to happen with that? Smart IDs were almost stopped in Congress. It's unclear what DHS will do with the ID standard they're supposed to come up with. Matrix, I think a very effective program. I won't speak for Jim Dempsey, but Jim and I were involved with that to some extent. It sort of brought in as outside observers to look at the program. And from my perspective, this was a law enforcement data mining program that the states were involved with. I was quite comfortable with that program. It was an effective program with significant privacy safeguards. But that's been defunded as well. And finally, in California, at least the original version of the Savidian bill, SB whatever it is out here, was essentially a ban on contactless IDs that the state government or state affiliate organization would use. And so I think that this is in some ways a very strange debate. No one is talking about banning telephones. Yet, in theory, we could develop a telephone system that would be completely uncrackable. We could have not passed CALEA. We could essentially say that telephones have to be completely unable for government to be able to tap our telephones. No one's having that debate. We could have a law that says we're going to ban cameras. No one's having that debate, so the government can take pictures of you when you come to a rally. We're only having these debates really about new technologies where there's an opportunity to essentially stop the technology. And I guess my sort of bottom line answer is, I think this is a fundamentally flawed debate. And I think what the privacy community could make an incredibly valuable contribution, and a needed contribution, is to fight for the rules about how these technologies are going to be put in place, not fight the technologies. And in my perspective, what they've been doing is largely about fighting the technology, saying, we don't trust government. We're afraid that these bad things are going to happen, and so the best answer is to just stop the technologies. First of all, I don't think that's possible. At the end of the day, we'll be in a hypothetical world where in 20 years everybody is using everything digital, except the government, which is mired in paper and inefficiency and is a laughingstock. And then a few more Katrinas where we don't have government information systems to share and to deploy resources, and it'll be pretty clear that what we've got to do. So I think we lay out a number of principles in this paper, And the first principle is, rather than bar new technologies as a preventative measure, we should put in place and enforce clear rules to protect privacy. Now, I want to make it very clear that I'm not advocating that we employ these technologies without very stringent and very good safeguards. But what I do object to, and there are lots and lots of examples of it, where we just simply, the debate is about fighting the technology itself. And that is where I think we're doing a real disservice, because it's not as if these technologies are being deployed because government wants to spy on us. The technologies are all trying to be deployed because they're responding to a very significant need that the technology can help solve an important government mission. And let me just use the case of the London traffic cameras as an example of how you can put in place rules ahead of time that are privacy enhancing, but at the same time allow this mission to occur. At least in terms of the London traffic, in terms of the traffic congestion charging system that the Mayor of London put in place, you drive into the zone in London, and you have to pay money, and if you aren't signed up for it ahead of time, you can still drive in there and it takes a picture of your license plate. Now, they could put in zones, but it was basically, little things where you got to put a card in. It was basically impossible. So they did this traffic license reader system. Now, the way it works is if you drive into London, it notes your your license plate, and it checks on the database. And if the database says, yes, you have paid, you're up to date, it deletes the record. It is now blind. You have not been there according to this system. If you haven't paid, the database says you haven't paid. You again get sent a little notice in the mail, and you have to pay the notice. And until you pay the notice, that record of you being in London is still in their database. As soon as you pay the notice, that record is automatically expunged from the database. So essentially, we have a system that we're built into the architecture. I would argue we have very good privacy protections. It's not a system that's being used to record information about people's traffic patterns in perpetuity. It's just using them for one clear purpose and then discarding the data when that purpose has been accomplished. And I think the way we need to think about this is that there are many, many cases where we're using technology essentially to automate paper or person functions. And so to me the analogy is when people say we shouldn't have security cameras on the street, where this is in many, many communities they're deploying security cameras, and the fear is, Big Brother will be watching us with security cameras. What if we just employed twice as many police officers and we had them standing on the street corner out here watching what we do and writing it down? That's what we do right now. That is essentially how law enforcement works. There's no difference between that and security cameras. If keeping data in databases is okay, why is it not okay to link databases? So one of the big, I would argue, very important changes we need to make to our driver's license system is to link state driver's license systems together. So that when I'm a when I'm a person who has lost my driver's license in one state and I want to go to another state, it's somewhat easy for me to do that because the driver's license systems are not linked. So why is it okay that California has 20 million records in its database, or however many there are, but we can't create a national linked database of all the state DMVs? And that is essentially what privacy advocates have said. We do not want linked databases. If it's okay to use, I used this example this morning in a comment, if it's okay to use barcodes to record my purchases, why is it not okay to use the exact same technology, at least in the commercial environment? There are issues outside which I think are frankly way overblown, but let's just use it in the store. The exact same functionality, I'm just recording information. Now, instead of the store knowing I bought Arrowhead bottled water, they know I bought this particular bottle of Arrowhead. Does it make any difference? I would argue it doesn't make any difference. So I think that when we think about these sort of public policy issues and weigh in on them, I think the major principle should be, let's not ban the technology. Let's put in place rules to use them correctly. The second principle would be about data mining, which in many ways I think is sort of the most, the biggest third rail of this whole debate. And any time there's any sort of even talk about data mining that the government would use, there's sort of a visceral fear that people that somehow will be using this in some sort of Orwellian scheme, that somehow the government is going to mine data and they're going to put it together something about me and they're going to start to investigate me and maybe even prosecute me. And I think the way we need to think about data mining is to separate out, there are two important functions that data mining can serve. One is simply about following up investigations, and that's what the matrix database was all about. Probably the other problem with these government things is they hire people who don't have any PR background to name these systems. I mean, the matrix is like you couldn't have picked. Then Jim, what was the one on
Carnivore.
Carnivore. I mean, sort of note to DHS. Pick nice, soft, fluffy names for your stuff. But in any case, matrix was essentially somebody knows that they see somebody on the street, they've abducted a kid, and they have a partial plate number. So they go and they investigate that. If you were unfortunate enough to live in Washington during the sniper attacks, I got to tell you, that was a very unpleasant time to be in Washington. I remember taking my 4th grader to school and seeing a Secret Service, armed Secret Service man outside the school door. Soccer practices were canceled, you name it. Well, one of the reasons that they were able to get John Mohammed, I think that was his name, was that they used data mining to track. They had some limited information about that. They were able to use that, and they were able to identify him. So I think in terms of data mining, we need to distinguish and put in place very clear rules that separate out, in this case, sort of investigations from phishing. And the example in the camera case would be, we don't want to record camera data so that somehow we'd have some algorithm that says if you drive from here to there to there to there, you're probably a drug dealer. I think that would be an inappropriate use of the technology. But using the technology to collect, to say, oh, by the way, we have a plate number, we know the person's likely to be a criminal, let's use that to find that likely criminal, I think makes good sense. And third principle is that government use of information is much more risky, if you will, than commercial use. I think in a lot of ways the sort of fear about commercial use of data is frankly a lot overblown. I really don't care personally whether somebody knows I bought a set of golf clubs and I start getting golf magazines in the mail. But what I do care about is if the government starts to know a lot about me and they have the wrong information and it starts affecting my life. And I think there were some very legitimate concerns, for example, with CAPS 2 that I agreed with many of the people who opposed the implementation of the way CAPS 2 would work. This was the flight passenger screening system. Because one of the things CAPS 2, at least in its initial design, would do would be to prevent me from even getting on an airplane. Well, what if the information is wrong and I have an important flight to make and they screw up? So I think the third principle we say is essentially that federal government information needs to be held to a much more stringent standard. And fourth and last is that we need to put in place, as I said, very clear rules and audits and technologies designed into the technology, the architecture, about how these systems can protect privacy. So, for example, I know Jim and I are both on the Markle Foundation on National Security and Information Age, and one of the things that the Markle Foundation has been pushing is very aggressive use of IT to deter, not deter, but to find terrorists before they strike, and including data mining and linking databases and all that. But one of the things Markle has pushed very strongly for is building in security and privacy into the systems, including things like electronic audits. But also other things, independent third parties, certainly legislative oversight, comment periods during development of these systems. Let me just close by saying I really think at the end of the day this all boils down to really one fundamental system, one fundamental question, and that is, do you really trust government or don't you? And I guess I have to say, if I lived in China, the answer would be no. I wouldn't trust the Chinese government. But if I live in the United States is a democratic system that's largely open. We have an incredible array of civic organizations who I commend, like the ACLU, who raise these issues, and EFF and other groups. We have a legislative process, we have a judicial process, and I would argue essentially that the system is not perfect. But for people who raise the specter, when they say things in these debates like, we will move to a show us your paper state, I mean, what planet, I'm sorry, where is any of this technology related to moving to a show us your paper state? I think the question really is, do we think the U.S. government and state and local governments are generally open and transparent? And I think the answer is yes, they are. And I think when breaches or problems happen, we find out about them. Now, I'm going to close by saying, I felt a lot more strongly about that last statement than I did until I found out about the NSA wiretapping that Bush was doing. Because I was like, look, this, I had debates with people, Herbert Hoover and J. Edgar Hoover, those days are past. We're not going to ever go back there. And I have to say, I'm very disturbed that what I think the Bush administration is shooting themselves in the foot. On the one hand, they want these technologies very, very badly. And on the other hand, they're basically doing everything they can to make people who are like me and other people like me, I think are sort of pragmatists. You might think I'm not a pragmatist, and in the middle, I put myself there, who are concerned about privacy but also want to see technology, and make people like me question whether we can trust an administration that does these things. For example, that last one, somebody mentioned this morning the passport, the secure passport initiative, which was basically going to be actually, I hate to use the term RFID. It's really not RFID. It's a contactless ID, which you'd wave when you go through secure immigration, or passport control. And I have to say, I opposed that initial deployment, and I said that publicly in the press and other places. I thought it was a ridiculous idea that they would deploy an unsecured, unencrypted, contactless ID for your passport information. But I didn't oppose them putting a chip on the passport. What I opposed was putting a chip on the passport that was unencrypted and unsecured. And I just wish the debate was about those sorts of issues, because that's not where the debate is. The debate is about, we shouldn't put chips on passports. This is turning us into a big brother state. And my view is it's not at all. If we put very secure chips on with the right rules in place, I think we're going to be a long way down the road of both securing privacy and at the same time being able to accomplish these very critical missions. So thank you very much.
I'd ask now for 2-minute comments from each of our other panelists. Jim Harper.
Rob and I are both here from Washington, D.C., though I grew up in California. In the House and Senate committee meetings on the floor, there's always a tradition as you sharpen your knives, you say how much you like the person that you're about to talk about. So I do just want to note that Rob is a good friend of mine. I always enjoy seeing him. Always has something interesting to say. He certainly provided us with a target-rich environment as far as comments are concerned. I'll make 2 quick points, and I want to be quick. And in Washington speak, that means I won't be quick. I think he's missing the point that a lot of privacy advocates make, and that is that the affirmative case for many of these programs have not been made. Privacy advocates do squeal, and they should squeal, because a lot of the programs we talked about, not all, but a lot of them have very few benefits if you actually study them, and certainly not benefits that outweigh the privacy consequences. Predictive data mining. He didn't speak specifically of predictive data mining, but it's a favorite interest of mine currently. Predictive data mining is not just something that has no theoretical basis. There's actually good theoretical evidence that predictive data mining won't work. Direct marketers, who we talked a lot about this morning, have thousands, if not hundreds of thousands, of patterns on which to go in building their algorithms, and they get response rates at best in the 6% range. And yet your federal government is working on programs that would use the same thing to try to develop investigational leads. They're thinking that somehow they can get it down to where they make a mistake only 0.1% of the time. And I think it's just basically impossible. Yet it goes forward. Privacy advocates squeal because the privacy consequences are huge and the benefits are nil. Embedded in Rob's thesis is also trust us, trust the government. And he basically put that question forward at the end of his talk as his basic thesis. I think that's a fundamentally mistaken thing to do. I'm a proud American. I'm proud of our government. I think our government is one of the best in the world. But that doesn't mean I trust it. And you don't have to trust it to be a good American. So I don't. All programs grow. All powers grow. There are only a few examples where that hasn't been the case, and I'll get to that. But take the Social Security number, for example. Issued originally to administer one program, it's now our uniform national identifier, pushed forward by the federal government and adopted by the private sector. The new hires database, which was instituted for immigration control, has been moved to different uses again and again and again. What these programs lack is a fail-safe. That is, if democracy fails at some point, and heaven forbid that it should, programs that collect data and amass data and unify data in one place provide no fail-safe. In Holland, before World War II, they had a wonderful prim system of records about everybody in the country that had a great deal of information, a card file, because they didn't have databases at the time. And obviously the Dutch thought that nothing bad would come of that, but then the Nazis came in, and it was very, very useful for the Nazis to administer horror. So we don't have to trust government to be good Americans, and I think we're actually being good Americans when we don't trust government. I mentioned earlier that all programs grow. There are only two exceptions that I know of. When the crazy Republicans came into Congress in 1995, I think there are two programs they shut down. One was the Administrative Conference of the United States, which did administrative law, and the other was, I think, the Office of Technology Assessment. Rob worked there. He lost his job, poor fellow. I'm inviting him today to go to work for the Transportation Security Administration, and hopefully Congress will set their sights on that target next.
Good. Thank you. Jim Dempsey?
Thanks. Rob, good paper. I agree largely with all of your principles, although I have one threshold principle that I would add, which Jim Harper alluded to, and that is the effectiveness threshold. You allude to it a little bit, but you do it sort of before you get to the principles. I really think from a technology assessment, a privacy assessment perspective, the first question has to be, does the technology work? I think if you look at CAPS 2, from my perspective, having spent a lot of time at TSA, the reason why CAPS 2 failed is because TSA could never articulate what it was trying to accomplish and never was able to prove, never even really completed a study on the effectiveness of the use of commercial data, which was one of the linchpins of CAPS 2 as initially proposed, never able to show that it was going to produce any benefit. And I think time and again, and maybe Peter can comment upon this, one of the advantages of the privacy, you have a situation now, I think, in government and perhaps in industry as well, where the privacy officer is the one forcing the operational people to define their mission. People come forward with a literally half-baked idea and they say, give me a privacy policy. Let's go to number 1, 2, 3, and 4 on your list, and let's get the policy right. And the privacy officer says, well, tell me what you want to do. What are you going to accomplish? What data are you collecting? From whom? For what purpose? And show me how it's relevant to the mission at hand. And on CAPS 2, there was not a clear answer. There was never a clear answer to that question. You cannot build a privacy policy until the mission is defined and until the effectiveness of the program is defined, because first rule of fair information principles is collect no more information than is necessary to achieve the purpose at hand. And if you cannot show that the information is necessary to achieve the purpose at hand and that it will achieve the purpose at hand, then you can't even get over the first hurdle of your privacy design. So I would certainly urge you to amend in future iterations the principles. And maybe members of the DHS privacy panel here can't talk about it, but I can. The DHS privacy panel has drafted a privacy framework for the government, which is still sitting in draft form from what I understand. I've never seen it published.
On the website.
On the website. Oh, good. So it is public. In which their first principle, I think, is, or their first step is, do your effectiveness assessment. First, determine what is your mission and will the program and the collection of information satisfy your goal. Then we can get to the other privacy questions about data retention and redress and go down through the fair information practices. Second point, Rob, I definitely welcome your paper to the extent that it is a call for privacy pragmatism. I work for CDT, which was founded by Jerry Berman. Nat Hentoff once described Jerry Berman as the man who never even whispers wolf. We don't cry wolf, we don't even whisper wolf. And we never use, I don't think the words Big Brother have ever appeared in a CDT publication. And I'm not sure that Orwellian has. You can Google it right now and prove me wrong, I guess. But we tend to stay away from Big Brother, and this is the first step to Nazi America, etc. But, you know, at some level, I think the privacy advocates will stop hyping the privacy risks if the technology proponents would stop hyping the technology benefits. You know, take the Patriot Act, for example. The Patriot Act, I will say, and I've been saying for some time now, it's neither as bad as I have claimed, nor is it as good as the Attorney General has claimed. It's not as important and powerful and potent for law enforcement purposes. It's not as bad from a civil liberties perspective as some of the rhetoric would suggest. But it's a very interesting thing, and I don't know if there are any journalists left, but I really would ask all my colleagues, both in government and in the private sector and in NGOs, several times in the past week or two, I have talked to a reporter and said, well, you know, I can see both sides of the story there, and here's, you know, I understand what they're trying to do, and there's a kernel of logic to what they're trying to do, but here are the problems. And the reporter has said to me, well, I really need someone who's going to be just critical of it. I don't want someone who's, because you know how a reporter, the way a reporter, in the way media now works today, you know, fair and balanced, you decide. Fair and balanced means we provide two extremes, and we never provide the middle. We get someone way over here saying this is going to stop child abuse and prevent terrorism and cure cancer, and then we have people over here saying this is leading us down the road to Stalinist communism. And that's considered balanced. And I think if you present only the extremes, you're never going to get the middle. And I think as public policy practitioners, even though, you know, the reporter calls, he's already got the government position, he wants the anti-position, I really, you know, we've all got to resist that because it gets us nowhere. And I feel sometimes, Rob, you go a little bit too much into the unquestioning side on the pro-technology side. And I think we've got to say there are two sides to a lot of these issues. Data mining, just one quick thing there. Data mining is like word processing. You know, General Hayden went before the press club earlier this week and said over and over again, we're not doing data mining. To which my reaction is, then what are you spending my money on? You darn well ought to be doing data mining. What is data mining? Data mining is extracting knowledge from large sets of information, large data sets. I think that's data mining. Data mining is analysis. Data mining is using information. Now, consequently, you can't just say, I support data mining or I oppose data mining. That's like saying I support or oppose breathing. It's everywhere. It's processing of information. And I would prefer not to use ever the word data mining. Data mining can be a powerful tool. Sometimes yes, sometimes no. I happen to think that some of the predictive, when you talk about data mining in a predictive sense, you know, did he buy fertilizer and rent a truck kind of thing, I think is, you know, the false positives there, in my opinion, are way too big. If you're saying, is there a guy named Mohammed Atta renting a car in the United States or living in the United States, I think that's a perfectly obvious, legitimate. I mean, assuming, you know, you have some reason to believe that Mohammed Atta is a terrorist.
And that he's not using an assumed name.
And not using, well, sure, but that's, I mean, part of the process then. But again, people tend to give the technology this magic. I'll leave it at that for now. I have some broader points. I hope we get time to come back to those.
Yeah. Joan, McNabb?
Just one thing on the point about government needing more stringent privacy protections than the private sector. Certainly government needs stringent protections and maybe even more. But I don't want to be one of those extremes, but I do think that there is harm that can and does occur from business commercial uses and possession and collection of personal information. Identity theft is one of them. That is, a lot of information is in the hands of a lot of people, and a lot of it is going astray. Some of it seems to be going astray into the hands of people who use it to commit identity theft, which can cost people money, send them to jail, and a bunch of other things. Also, one of the things that real physical safety is jeopardized often enough for certain people by the commercial uses of data in posting all sorts of information on websites, such as where everybody lives. I mean, yeah, that's public information in a sense, but it's not as, there are a lot of people who would just as soon, law enforcement officials, for example, not have their home addresses all over the internet, even though it's public. They've taken certain pains to not have it be public, and yet it will still get back in there through public records, and that's just commerce.
Just three quick things. First, about this concept of value-neutral technology, and I want to talk a little bit about what efficiency in technology actually means in practice, and then talk briefly about these inherently evil technologies like data mining. A lot more of this was emphasized in the paper than in the presentation, but I think there are three important topics just to at least put out into the open. Excuse me. The first is this idea that technology is neutral. Just in reality and practice, that's just not true. There's no such thing as value-neutral technology. It's all about people. Even though it looks like a computer and it looks like a screen, somebody built that. People got together and figured out what that should look like. And what you're really looking at when you look at technology is just a collection of people's choices. And in a prior life, I was a chief information officer responsible for building technology. And if you ever want an interesting exercise, take a piece of law or anything and try to distill it down to flows of information. You know, read a law and figure out what information is actually being talked about, who would get it, and what would they do with it. It's insane. It's just, and if you look at the way laws are actually written, it's impossible. So when you look at technology, what you're really looking at is individual people making individual choices about which different tools to use, how those tools should fit together, how this thing should operate, and why, what it should do and why. And there's a huge gap in the actual development process between the people who want something and the people who have to deliver it. I can talk about that in more depth a little bit later if you want, but there's this huge gap in the people who expect technology and the people who are responsible to give it. They basically don't talk to each other. So if you put the two things together, this concept that, well, technology is just neutral and it just works, it's magic, it does whatever it wants, and you don't drill into the actual choices that are there, and you also allow this gap in communication to exist, what you end up with is technology that's doing things with information that nobody intended, nobody understands, and nobody's watching. And that's a big issue, and everybody should go resolve it. The second thing is this idea of technology as just doing things more efficiently. And I think that's true, at least potentially it's true. But in practice, what's usually happening is somebody's coming up with a new idea. Again, you have that gap in communication. The guy who gets the project on his desk, the developer, is thinking, all he sees is a generic, abstract problem. Do this with that. Get something. And so it really becomes this intellectual exercise in building the best solution. You know, here's a two-line problem, build the best solution, and what you end up with is new things. And even which is different. We're going to make this more efficient, but in reality what we're doing is something totally new. You know, we're giving people new capability to do things that nobody understands and nobody's paying attention. Another thing that you could get, if you're lucky, is actually doing the exact same thing that you were doing it more efficiently, and what you see is what you're really doing. What is the actual implication of doing that thing for real? And for real, I mean doing it at scale. It's not how many pieces of paper can you shuffle in a day, it's what you're actually allowed to do, doing it with all of the information that exists, every 30 seconds by yourself. What is the actual drawn-out implications? And that changes the conversation. Again, it forces you to look back and go, well, what are we actually doing? What are the implications of what we say is okay? If you actually build it in an operational setting to scale, meaning draw the conclusion all the way out and look at the final result there. And just finally, this idea of inherently evil technologies, data mining is evil, RFID is evil, everything is evil. And I don't think it's a question of focusing on the technology as was discussed earlier. I think that's true. It's a misdirected focus. I think the real focus ought to be on the concept of delegation. Who are we delegating? Because people are still making the choices. Even if it's the person who built the data mining system, like I said earlier, somebody is still making a choice. It's like the difference between a stick shift car and an automatic car. The car is still shifting gears. It's a question of who's been delegated the authority to decide when the car shifts. I like a stick shift because I like to be able to decide when to go up, and usually it's when to go down, and what to deal with big puddles of water and all that kind of stuff. I want to be able to make those decisions. It's the same process. If I delegate that to somebody who designed the car, who then asked somebody else to build it, it's the same choice of just being given to somebody else. So I think in looking at technology, a final thing to do, which will, I think, drive really good results, is to look at what the choices actually are and who's been delegated the business of making those choices. Thanks.
Bill Fenwick?
Well, I'll try to keep it short because I've put forth what is my primary thesis. I don't think that it is a question of trust. I think that if you use technology, transparency is a lot easier. And if you give me the option of trusting versus the option of seeing what's being done, I'm going to take the latter. I'm going to take the transparency. Yes, there are some things that you don't, it's not like you're going to print out a 15-foot stack of paper and say, there it is. That's not what I'm talking about. On this issue of efficiency, Peter rings a bell with me because I started my involvement with information technology as a systems control and scheduling supervisor. And that meant that I had responsibility to make all the damn things work. And supposedly I was told what they were supposed to do. I think the problem with efficiency is mission creep. Add to that technologist blue sky. Because you have, somebody says, okay, well, now, I've got the ideal application here, and here's what it's going to do for us. It's going to do this 8 times faster, and it's going to mean that we can deploy these assets over here. And what happens is, when it starts getting implemented, 15 very clever people say, hey, look, you know what? We could do this. We could do that. So mission starts to creep. And you can't, if you don't have the defined objective, and if you don't make the creator stick to the defined objective, not mission creep. Yeah, sure, you can do a whole bunch of things, but that's not what you started out to do. The last point is simply the one that I will just re-emphasize again. I don't think we've got a choice. We've got a choice in how we do it, in the sense of how the technology is employed and what measures we take to protect it. But I do not believe that we have a choice of not using it. I think what we've got to do is we've got to figure out how to use it well. And that's where one of the points that none of us have mentioned A big problem with e-government is something that's called turf. Because for an efficient use of e-government, people are going to have to give up turf. And, you know, it's just not in the nature of the bureaucrats or anybody else to give up turf. But that's what's got to happen. And the only way that'll happen is if the people, like the people in this audience, who are concerned about these things, in fact, start saying, we want you to do it, and we want you to do it right. Because ultimately, everybody is playing to the public. That's what they're playing to. And you're the public. So if you think that all this can be done by somebody else without you getting involved, I think you're badly mistaken. It's just not going to happen. And I hate to be yelling Chicken Little, or as the case may be, wolf, but I just see the government getting farther behind every day in what they're supposed to do. And, you know, the only thing that I fear total government control. But I also fear as much total government chaos. That's all.
Thank you. Thought I'd give Rob maybe 3 minutes here to counter these assaults.
These were vicious, unprovoked assaults, especially from my friend Jim. No, I just want to comment, I guess, on the two Jim's comments about principle one should be make sure we deploy technology that has real benefits. I completely agree, and I think it's an excellent point. And to the extent the paper didn't stress that, it's a limitation of the paper. I have to say, though, and I would agree I think both Jims, again, predictive data mining would probably be a good example of that, where I think the benefits, at least given what we know about technology today, are quite dubious. Now, should we have gone ahead with R&D into predictive data mining? I don't have a problem with doing that, which is what total information awareness was about. Having said that, though, I think you're absolutely right. But I will say that I think the sort of opponents of technology, the way they start every single argument in this, particularly in the press, is the technology has absolutely no benefit. And I just think in most cases that's simply wrong. In many of these cases, and I'll use the smart ID as an example, has significant benefits for mission. Now, there are other areas that don't, and so I agree with that. The second point, I guess, is, and again, maybe the way I phrased this at the end there, I'm not talking about trusting government, and certainly not trusting an individual administration. What I do trust, though, is I trust our governance system. And I have an enormous amount of trust in that. I certainly can see where individual administrations can break the law or do nefarious things, but I believe at the end of the day, unless sort of somehow the whole thing breaks down and we go to a complete totalitarian state, at which point I'm not too worried because they have more guns than I have, so I don't think it's a relevant issue whether they have information. They have guns. First of all, it's not going to happen. So the issue is, do I trust the system that we have in place? And the system that we have in place includes things like a free press, hundreds of thousands of bloggers, Jim's oversight here, and Cato and other groups, other civic and privacy groups, and Jim Dempsey, and Congress, and legislatures. I mean, we have an enormous amount of checks and balances in the system. I'm not that worried about going off the deep end. What I'm worried about is that we're not getting the balance right. And I guess the last point would be, Jim, you sort of issued maybe somewhat of a good challenge there about, which I interpret as who will disarm first. And, I think you probably, I would put myself in the camp you're in, which is I think I'm a moderate on the benefits of the technology and the privacy thing. And I agree that the debate is one where there's hyperbole on both sides. But I just don't see the disarmament happening. Because I see, particularly if the pro-technology people were to disarm, if you will, this is how arms race happens. I can't trust the sort of privacy extremist side to disarm and frankly, stop saying things that are just simply flat out wrong, and they know they're flat out wrong. I just don't see that happening. Now, I wish that would happen, and if that were the case, I think we'd have a much better debate. And what I would love to see these debates about is actual debates about effectiveness, about mission, about rules, and not debates about, to me, one of the worst examples of this was Catherine Albrecht's book, Spy Chips. I mean, you might as well write science fiction. It's just pure, not all of it, but most of it is pure science fiction. And the problem with this debate, and this is my last point, nobody knows enough about this technology anyway. Average people don't. So you can say whatever you want. You can say walking around with an RFID chip, you can be tracked by a satellite. And people will go, my God, you're being tracked by a satellite. In fact, someone alluded to that today. I mean, it's simply not possible. So I guess I would sort of second Jim said, and I think what we need in this whole debate is a very important debate, and we need to sort of tone it down and bring it back to the center and bring it back to how do we put in place the right rules. So thank you.
Thank you. What I'd like to do now is take a few minutes and ask each of our panelists to talk about an emerging, a significant area in this landscape of privacy and policy, and then hopefully leave enough time to generate some questions, both with respect to Rob's presentation and some of these new emerging significant topics. Maybe Joan would like to start, maybe 3 minutes or so on describing California's venture in some of its statutory enactments dealing with privacy issues.
Okay, cut me off when I hit 3 minutes.
Okay.
As I expect many of you know, most of you know that California has indeed been the laboratory of privacy law for the past, 6 or 7 years. And as I count them, there have been 77 pretty significant bills passed and enacted, a lot of privacy laws. And in looking at those lists, which are all on our website, if you want to look at them at privacy.ca.gov on the legislation page, I looking through to see, okay, based on what I know, have any of them actually been successful in protecting our privacy? And I think 2 of them have. And I don't know that some of the others haven't, but I can see 2 of them that actually seem to have produced intended consequences, which is kind of rare in the legislative world, I suspect. One of them is the law about Social Security number confidentiality, which is in the Civil Code, and it was passed, took effect, I think, in 2002, or it was passed in 2002, I forget which. And this is the law that bans the public posting or display of Social Security numbers. And among the evidence that this is having an impact because its intention is to protect people from identity theft, from abuse of their Social Security numbers. It doesn't say that they can't be used, it just says they can't be publicly posted or displayed. And we've seen, for example, if you live in California, your health plan card doesn't have your Social Security number on it anymore. That's a little bit less exposure. Maybe even a little more is if you're a student or a professor or a employee at a university where uniformly your identification number was your Social Security number, because it can't be on the card, it's not the ID number anymore. So every professor doesn't have every student's Social Security number on the class lists anymore. They aren't posted on the walls anymore. Now we can just get them off the websites. That's another step, though. But there have been some actual changed practices as the result of that law, and changed in the direction that the law intended them to change. The other one is the one that the previous panel was talking about, and that's the security breach notice law. And yes, a stated intention of that was to give people whose personal information of the kind that identity thieves are after, name, Social Security number, financial account number, or driver's license number, that's the kind of information that triggers the requirement, that if that data has fallen into the hands in unencrypted form of an unauthorized person, then the data subject gets a notice. So that gives the data subject sort of a fighting chance to take some protective actions, like putting a fraud alert, or better yet, a security freeze on their credit files to stop new account identity theft, which is a difficult time to deal with. But where I see it's really been having an effect, which was another part of the discussion of the intent in the legislature, is in changing the privacy and security practices of organizations. And it's done this by putting a measurable cost on insecurity. Information security has been seen traditionally as an expense, but not a profit center or not having any real benefit. But now we can see, at least to what some of the costs of insecurity are, and the costs from those who have experienced breaches can be real specific. Like I know from one financial institution that experienced several breaches, $25 per notice. So that's one hard cost. That's the cost of printing, mailing, and a 20% response to the offer of credit monitoring, plus the reputational cost. And I'm sorry I can't remember it, but the Panelists Institute did a survey of consumers asking how likely would you be able to leave your financial institution if it had 1 security breach, 2 security breach, 3 security breach. And so this is people reporting. But it also asked them, have you gotten a notice? What did you do? And there's a definite inclination of people to leave after 1 or more breaches. And I know from a couple of financial institutions that they did lose an undisclosed percentage of customers. Then we see things like ChoicePoint where there's share price, losses. So it definitely puts a cost on insecurity. The other specific ways that I've seen that it's changing practices in a privacy protective direction are, for example, in data collection practices. One example is blood banks. There have been a number of blood banks that have experienced security breaches, usually, as many breaches have been, a laptop that was stolen when they were going someplace to draw blood with a remote, one of those setups they do. And the laptop was stolen, and of course, the way they identify blood donors is by their social security number. So I was on the phone with about blood bank breached entity number 3, and I said, now, why is it that you use social security numbers? I know I give blood, and I know they always ask me and look it up. Is it just a customer ID? He said, well, I think so, but we also have a donor number. Let me check. I'll let you know. So he went off and called me back and said, well, here's what I found out. In the past, the distant past, we got most of our blood donors from hospitals. They came with their patient ID number intact, which was their social security number. For the past 10 years, we've been giving people donor numbers. We actually don't need the social security number. So we're going to stop collecting the social security numbers. We're going to go back 10 years to the point at which we started giving them a donor number and delete them. They do have to keep their data forever for epidemiological purposes. And I encourage them to go to the next meeting of the Blood Bank Association and spread the word. Another instance is one of the many university breaches. In fact, this was UC San Diego. It was in the paper. One of their several breaches. Among the data was always the social security number, were people who had applied 15, 20 years ago and not gotten in. So imagine how thrilled they were to get this notice. And so they asked themselves, why do we have this? After 15 or 20 years, if these were paper records, they would be long gone because they take up so much room. And so they changed their data retention practices. UC Merced had a breach before they even opened. And they immediately changed the way they set up their databases because they were new. So they could actually start off with procedures to protect the sensitive information like social security numbers. It took the breach to get that message. Am I through? Is that my time?
Yeah. 30 seconds to wind up if you'd like.
Okay, I have a couple of other examples. In data security, encryption, more than half the breaches that we've logged, and nobody has to tell us, we just keep up through the news media largely, more than half of them have been lost or stolen laptops, storage media, PCs, which turn out to be portable, what do you know? And nothing was ever encrypted. Now there's a widespread use of encryption on portable media, or the equally effective measure of not allowing sensitive information to get onto portable devices. The state has passed an encryption policy for state government, so state laptops that have the notice triggering information have to have it encrypted if it's on a laptop, including the Franchise Tax Board, which is good news for all of us.
Thank you. Pete Sand, 3 minutes. What does the audience need to know about privacy impact assessment?
The Privacy Impact Assessment is a requirement under the E-Government Act of 2002, and it basically requires government agencies, federal government agencies, to review the use of technology, review a system, and write up what the potential privacy impact of using that information that way will be. And it actually addresses another gap. I mentioned earlier that there's a gap between people who use technology and people who build it. That's kind of a secret gap. Most people don't realize that there's a popularly held gap, a gap that people are more commonly familiar with, which is this concept of a gap between law and technology. That technology races far ahead and nobody can catch it, and slowly the law plods along and figures out what should be done or should not be done. And some people say that's a good thing because it requires a lot more thought. You know, the law requires a lot more thought. You should do a lot of thinking about what is permissible and what should not be. And technology is just crazy, and let it go, and we'll worry about it later. The problem is that the law is supposed to, or does, regulate the activity of people working with other people, interacting with other people. But the delivery system, the way we work nowadays in real life, is through technology. So you use IT to communicate with each other. You use email. In fact, I work physically close to a lot of people, but I usually use email because it's faster and it's just easier, and I know what I meant when I wrote that, and I can point back to it. So we use technology as a vehicle for a lot of our interactions, even though the rules are law. And when there's a gap, what people are actually doing is different from what they think they're doing, what they think they should do. And the Privacy Impact Assessment helps, I believe, to fill that gap, to remove it, because it focuses on the appropriate use of personal information. In the DHS Privacy Office, we do privacy work, obviously. Most of it is focused on information privacy. And our standard is the appropriate use of information. Information should be used appropriately, specifically personal information. Personal information should be used appropriately. Personal information piece is the link between the person and the technology, the person and the information, because it's any information that could be used in any way to identify an individual. So we use the label personal information, but what we're really talking about is when does the use of information affect other people? And then we talk about appropriate use, which is use that is founded in sound, legitimate public policy, law, agreements, things that people have sat down and figured out, well, these are the rules, and these are what the rules should be, and this is why, and this is what we should do and why. The Privacy Impact Assessment looks at both of those things and brings them together. In fact, we have a little form that we send out first. I'm summarizing a huge, complicated mess, but what we send out first is something called the Privacy Threshold Analysis, which basically asks one question of people building systems. Are you using personal information? Is anything you're doing, does it use information that could in any way be used to directly or indirectly identify an individual? And they literally, it's a box. Check this box, and they send it back. And if they say yes, then we know we're in the game. And if they say no, then we do it ourselves and make sure that we're really not in the game. But the focus is really in the Privacy Impact Assessment, which is basically a whole list of questions that identifies what the information is, who it's collected from, how it's being used, why it's being used, all the questions that you would want answers to decide whether this is a good thing or a bad thing. And we build that into as much of the bureaucracy in our agency as possible. There's something in the IT department that looks for enterprise architecture alignment. There's something in the financial groups that look at alignment of programs. And as many places as we can find where there's just this mechanical machine that just runs and runs and runs and runs and runs government, we throw these things in there so they become a part of the mindless process of government operation. And so that's our process. But what you're dealing with still are these two groups, the people who develop technology and the people who use it. And just as a final punchline, I would advocate that you do what we're doing, you do what you can do to remove those gaps, the gap between law and technology and the gap between people who build it and the people who use it, by doing three things, knowing three things. The first is know the data. whatever you're doing, wherever you're doing it, know the data, know what the information is, understand it as much as possible.
30 seconds to wind up, please.
Second thing is know the rules. And the third thing is build the rules into the processing of the data. It's really basic stuff. And the good news is all the people are already in your organization. There's a bunch of people over here who are doing all the legal work, and there's a bunch of people down the hall who are doing the technology, and they've never talked to each other. And so I would encourage you to bring those two groups together. Look at things like data models, which are pictures that show the information, and process flow diagrams, which show what's happening. Understand what the affected parties are, the legal side, and the rights and obligations, and just put everybody into a room and have a conversation and see what comes up. And what you'll find is people realizing what's already going on, and through that you can build a better world.
Thank you. Jim Harper, 3 minutes. Real Idea Act?
Yeah, I've been focusing on the Real ID Act, which is legislation that passed early in 2005 to create what is effectively a national ID. You can quibble on the margins about what it is, but it practically requires people to carry a license or ID that conforms to national standards. I won't spend a lot of time with it because we are short on time. I'll just summarize by saying that this thing's basically Pol Pot, Stalin, Big Brother, 1984. All rolled into one. I'm just finishing a book on identification called Identity Crisis, How Identification is Misunderstood, Overused and Misunderstood. The book starts, which I think the most important part of it is identification theory, of which there's been very little study, so that we can actually understand what identification policies that we've always been backing into really mean. And it goes into then discrete policies that we have like Real ID. So I think it's a very interesting area, and it's an area that will be hot this year and up through 2007 when the Act should be implemented.
Good, thank you. Jim Dempsey, 3 minutes, please. Some new trends, search technologies, remote storage, location awareness. What should we know about that?
Yeah, 3 minutes, 3 trends. Peter was 100% right in pointing out that the technology has outpaced the law. And here I'm particularly talking about the government access issues. I think the same issues could be made in terms of the commercial side, but certainly the Electronic Communications Privacy Act, which was the last major rewrite of government access to communications laws, was in 1986. The Foreign Intelligence Surveillance Act was 1978. And we're now in the midst of what I think are 3 remarkable developments, revolutionary developments in a way, which completely blow apart the legal framework. One is what I would call the storage revolution. Gmail is the most prevalent or most familiar exemplar of this, but all forms of web-based email. The information about your daily lives is less and less being kept on your desktop or even on your laptop, not even on the server in the basement of your building, but on a network accessible from anywhere in the world, from any internet-connected computer or handheld device. Huge convenience in terms of mobility. Huge convenience in terms of storage capacity, and yet we're operating under a set of legal rules going back to the 1970s, Smith versus Maryland and the other business records cases, that are sometimes read, I believe overread, but sometimes read to say that what you voluntarily give to a third party, you lose your constitutional privacy interest in. Now, I think there are alternative analogies for that. There's the bailment and storage kinds of analogies from the physical world that run in the opposite direction. But certainly the Electronic Communications Privacy Act was written on the assumption that there was a diminished privacy expectation in what is stored remotely, and yet now driven by consumer demand, driven by the fantastic capabilities that are afforded by this storage and this flexibility, we are losing that sort of Fourth Amendment sphere protection as this information sits on networks. Next down the line, of course, is voice. Up till now, we've treated voice communications as largely transient, but with voice over IP, it's just like an email. It's a bunch of, obviously, of packets, and storage prices continue to diminish, and VoIP service providers are going to be offering the capability to store your voice communications. Huge, wonderful opportunities. I mean, how often have you said something absolutely brilliant on a telephone conversation and been unable to remember it the next time? With VoIP, you can now set your system to store your voice communications and to make them retrievable. Chances are it'll be stored with a service provider outside of your control. So just as your email is increasingly being stored remotely, so might your voice communications. The second complementary piece of this in some ways, which is not fully understood yet, is the role of search. Obviously, search has now become the killer app, I guess. Obviously, the Google situation is on everybody's minds, but we have, I think, evolved a new way of finding and accessing information. And again, it's remote, it's stored, it may or may not be personally identifiable. It clearly has First Amendment implications in addition to privacy implications, just in terms of the access to information. The third trend is location awareness, and I was just looking at somebody's predictions for 2006 in the tech world, saying that 2006 will be the year in which location awareness comes to fruition. Obviously, the cell phone, in a way, is a tracking device that most of us voluntarily carry with us, with the mobility of computers and mobile access. We're in one of the sort of capitals of wireless access, and the whole location function that comes along with that. Those three trends, believe it or not, and the federal magistrates who are at the front lines on these things are grappling with this. As you may know, there have been three decisions in the past 4 months on what is the legal standard for access to location information generated by mobile devices, particularly cell phones. Believe it or not, there is no law on the books, state or federal, addressing what is the legal standard for access to location information. I think it's not a communication. I don't think it's covered by ECPA. But it shouldn't be just ordinary transactional data. It's in many ways even more revealing than that. Now, I think in terms of responding to that, and there's a third, or rather a fourth, you could call it a trend, but it's an unresolved issue, and that's the issues of authentication and identification, which clearly nobody has cracked yet from even a technology standpoint. When somebody does manage to crack that so that you have, individually authenticated packets, then the jig is up, because then everything is identifiable. Right now there is relative anonymity online, relative, much less than people would like to think, of course. But with the storage revolution, the search revolution, and the coming ubiquity of location awareness computing, I think we do have to fundamentally look at the protections. The courts need to do so, and the magistrates are looking to the Fourth Amendment on this. And I think there's a lot that can be done in Fourth Amendment jurisprudence. There's clearly a lot that can be done on the statutory side. And third, there's a lot that can be done on the design side, which is what Peter was alluding to. Fenwick, Bill, in your comments from the podium at lunchtime, you made some derogatory comments about the sort of transaction costs imposed by lawyers, which you're entitled to do as a leader of the bar. But I actually think we need more lawyering at an earlier stage, in the design stage. I mean, technologists are good people, and they're sitting around thinking up neat things. And I don't think they fully appreciate the privacy exposure that they are creating. I think any company that is handling storage, search, or location data needs to think about, any company that runs a log needs to think about, what are we collecting? Because you know that the government's going to come or the civil litigants are going to come. And right now, for a lot of this stuff, the standard is very low. And I think that the whole concept of privacy by design needs to be a technologist's concern, and you need to get policy people, which in a way what lawyers, non-practicing lawyers are, you need to get the lawyers into that design process at an early stage. Thanks.
We have time for one or two questions of this panel. Do we have a...
Bill, want to say anything?
Question? We have a question right here.
Hi, everyone. Thanks very much. I wanted to go back to the issue of disarmament. And I'm pretty sure that those papers, please, and Orwellian comments are trademarked by some of my colleagues. But I did want to say, and you'd also mentioned the first version of the RFID bill, but for the past year, myself and Lee Tien, who's hiding back there, have been engaged in some pretty serious disarmament in terms of really working hard to come up with reasonable standards for how RFID tags or smart chips or contactless integrated circuits or whatever language being put in identification documents. And what we get back, and we've sat down with the industry and even said, if you have trouble with the standards we've come up with, we really want to hear from you. And we really get back no legislation at all, and no movement at all. And we see that in the New Hampshire bill, which I mentioned earlier, which is a notice bill. Just notice about putting in that a consumer document or an identification document has an RFID tag in it. And we get the AEA's comments that the legislature should not pass laws directed at RFID technology, but at the appropriate use of the technology. Don't ban the technology, punish the bad actors in a notice bill. So that's the kind of thing we get back when we are moving to really come up with reasonable standards. So I encourage you to join us to read the latest version of SB 768 on the ACLU-NC website. And we'd love to have your feedback, and we'd love to work with you on it, because we really, truly believe in putting in reasonable privacy protections. The time is now, and we're completely committed to that. So.
Thank you.
I will read the bill and get back to you. Thank you.
Is there a question? Last question as we close.
I have one for Peter. What's the compliance with your impact assessment requirement?
The compliance is the part of our office that actually runs the privacy impact assessment.
Yeah, but what I'm really asking is, how many people are in fact doing compliance assessment and reporting back on that before they are taking action?
The first step is actually pushed over to the people who are doing the development work. So we ask anybody who's doing a system development process to also complete the privacy threshold analysis and the privacy impact assessment. And then we review the drafts that come in. So they do the first round because they're the people who are closest to the information and the systems. They write it first, or we have a template and a guidance, and we send all that to them. And they do the first draft, and then it comes back to our office, and we review it and revise it back and forth, and then there's an internal approval process within our office. And the final product is actually, for the most part, published directly on our website, which is dhs.gov/privacy. There's a whole list of these privacy impact assessments that anybody can look at.
Terrific. We have a question right here.
If I could just, could I also respond to Nikki's comment, because I think she's right on target there. Because, I mean, I've had the same on the government side. Right now there's a CDT, ACLU, EFF are suing the Federal Communications Commission, challenging their order that would compel design mandates for making broadband internet access and VoIP applications more wiretap friendly. And CDT went to the Justice Department 2 years ago, and said, you know, we understand you have some concerns here, let's talk about them. And their attitude was absolutely not. We want it all. And just recently we renewed that dialogue. And in fact, we had somebody inside the government who was sort of sympathetic to saying, you know, let's really talk about this. And the word came down from the higher ups, absolutely not. And, you know, back in the Patriot Act, I remember vividly, it's in O'Hara's book, there was the staff, for the first time ever, called on the Senate side a briefing to go over the bill and to talk about the bill. And they invited both the privacy groups and the government. Okay, let's talk about this and see, can we agree on section this and section that? The government was livid that non-governmental people had been invited. And basically they insisted that they would speak and then they would leave. And they would not listen to, they would not engage with the privacy advocates. So, sure, they go out and say this is necessary to stop terrorists, which it really wasn't. And we go out there and say this is a terrible intrusion on privacy. And, you know, we had come forward and said, and those are two concrete examples, and I'm not surprised that there are others on the corporate side.
Question right here.
Yeah, Jim Harper. Jim Dempsey. I was a little confused. You said that one of the big three upcoming challenges is with respect to locational information, and that you thought there was traction to be had in the Fourth Amendment sphere. Are you suggesting that people have a reasonable expectation of privacy in their publicly observable whereabouts?
No, but the cell phone goes into a private sphere, and once you're in the private sphere under Cato and Knotts, there's a privacy implication there. So the tracking device on the highway is not constitutionally protected, at least under current Supreme Court jurisprudence. I'm not sure that I would limit it that much, but the cell phone clearly locates you inside private property where you are constitutionally entitled to a reasonable expectation of privacy.
Also,
it is becoming more, of course, with the GPS. The cell site is rough, but we're getting to the increasing sophistication on the GPS side, which gives you altitude as well as latitude and longitude.
I'll just pipe up on this because I've made the argument that people do have a privacy expectation in their movements, even though their movements could be observed in public. Go to a case like the Kilo case, not the property rights Kilo case, but the Ajima thermovision viewer case. The general rule you take from that case is that people who take reasonable efforts to protect their privacy also enjoy protection of privacy from unwarranted government intrusion. People who are traveling around a city have a reasonable expectation that they aren't being tracked and followed by individuals. And if you have an infrastructure that can follow you everywhere, the use of that by the government might, I think it's a stretch myself, but I made the argument, might invade a Fourth Amendment, recognizable Fourth Amendment privacy interest.
Do you disagree, Don, in terms of the public versus private?
Pardon me?
Do you disagree in terms of if to the extent that the cell phone can allow your location, even proximate inside a private space, and doesn't merely facilitate visual surveillance on the highway, that does implicate Fourth Amendment interests? That's where the magistrates are going, and that's my reading of Cato and Knotts.
A couple of
question here.
Very quick comments. One, back to the point that both Nikki and Jim were making about the need for engagement and dialogue. One of the impediments in this area is not just let's say, a lack of willingness to listen. That's part of it. But the other part of it is a lack of willingness to share extremely relevant factual information that bears on the public policy discourse. I'll give two obvious examples from what we've been talking about. With RFID, there has been an issue about what is the actual read range. People care about that. Much of the sort of public concern about the State Department's RFID passport began to really spark when there was a report that at a NIST trial that there were emanations read from at the test at distances much greater than the 10 centimeters that were part of the spec read range. Now, we have since then had some level of admission from the State Department that yes, indeed, it is greater than what we had thought. But certainly, I have not seen any public report that summarizes the NIST trials and tells us what the government has learned about this technology and its read range from its own empirical testing. It seems to me that it's insane and irresponsible for the government to attempt to make public policy decisions, and it has data about this, and yet it will not say, even in the face of people saying, well, if it's not 10 cents, is this true? What are the facts? We do not have the facts, and the government is concealing them. And that seems to be a major impediment to discourse. The same idea in the CHTLI area, where we have claims from law enforcement about the way in which modern telecommunications is going to inhibit the ability of the government to perform its lawful wiretapping functions. Now, EFF was never very impressed with the factual record that was presented even in 1994 with respect to CHTLI, but they did, at least, and we've seen the FOIA document, go out and canvass pretty much every FBI office and say, can you give us examples of where this has been a problem? Fast forward to today, as Jim well knows, the government has only offered the most vaporous imagining as to what the problems are, and they have not given us any hard factual data as to what those problems are. And so, my basic feeling is that you can, even if you have engagement, even if privacy advocates or the public are allowed to talk about it, if you're not given access to the information that's necessary to actually speak intelligently about it, we might as well just be going blah, blah, blah.
Well, thank you. I think our audience has been very patient. We're about 30 minutes over the announced time here. I understand we got behind a little bit, but wanted to make sure that our audience had an opportunity to hear some of these important issues that are developing from some of the people who know a lot about them. So if you would, join me in thanking our panelists for this presentation. And in closing, I would again like to thank our Yeoman Law Journal staff, and certainly Chris, Vince, and Alex for their wonderful work in making this thing, putting on a first-rate program here today. And let me thank all of you for being here and participating. Thank you now.